Hi, folks. Next up on TWiL, we've got Roger Skalbeck, Rob Hassett, Evan Brown, and me. We're going to look at Autobots and streaming. Hey, I thought it was the Decepticons that were the bad guys shifting copyright strategies. We'll look at a little marijuana and social media, yoga. Bruce Willis taking on Apple. Well, not so much. Drone tracking, all sorts of other good stuff coming up next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 178, recorded September 7, 2012. HTML5 saves democracy. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a free 30-day trial, go to sharefile.com, click the radio microphone, and enter the promo code TWiL. Hey, all, it's Denise Howell here, and you know what? I get it. It's the end of summer. It's been a long, active summer, and you're probably having a really hard time getting yourself out of the fetal position watching episode after episode of The Big Bang Theory. But we're here to help you out with that because we've got lots of interesting stuff to talk about here today on This Week in Law. Elevate your brain out of the gutter and off of the couch. We've got a great panel of folks to do that with today. We've got Roger Skalbeck. He is the Associate Law Librarian in charge of electronic resources at Georgetown. Hello, Roger.
Hey there. Glad to join the show here finally in person. This is great.
Hey, it's great to have you. Also joining us from Atlanta, Georgia, we've got tech lawyer Rob Hassett of InternetLegal.com and the law firm of Casey Gilson. Hello, Rob.
Pleased to be here. Thank you.
It's great to have you. And joining us, per usual, from Chicago, Illinois, is Evan Brown. Hello, Evan.
Yep, just the per usual Evan here today. Good to see you, Denise. Looking forward to our conversation.
Per usual and per awesome. Always great to have you.
Feelings mutual.
So we've got so much to go through. You know, I think there's almost more to talk about when there isn't some great big patent case sucking all the air out of the room, because there's lots going on, even when big cases aren't in trial. One really interesting thing going on that Roger brought to my attention as we were prepping for the show is sort of a content ID system that sites like Ustream and Justin TV and others are using for live streaming. And what it winds up doing is sifting through the live streams that are going on these channels. And I think in Ustream's case, it's only happening on the free streams, the ones that people have not, set up a paid account with Ustream or advised them in advance that they're going to have some big event that they're streaming. For, just the kind of John Q. public accounts, they have some technology in place that if, you roll a clip of something that is subject to copy protection, immediately it's going to pull down the stream. Roger, why don't you tell us what happened? What are was it the Hugo Awards that got preempted by this?
Yeah, exactly. And this was covered a little bit on Tech News today. But what happened is the Hugo Awards had a live stream of their event where Neil Gaiman was going to be presented an award. And, of course, these are kind of the sci-fi version of the Oscars. And they were showing it live on Ustream. And prior to showing it live on Ustream, they had a couple of clips that were shown. And probably the use of the clips was a fair use, but they had gotten permission to use the clips ahead of running the stream live and running the event itself. What happened in the process of it is that Ustream's content detection partner, which is Vobel, I think, detected that there was copyright protected or copyrighted material in the stream, and so they shut it down. What happened to the Hugo Awards folks that was unfortunate is that the live stream couldn't then be reset. They had no sort of trigger mechanism to say, whoa, this was a mistake, let's put it back and let's just keep things going. So as I understand it, for the rest of the award, nothing was shown. That was sort of one thing. And then their article in the Wired magazine that we found from yesterday, I think, highlighted a couple of other things. One of them from the Democratic National Convention, and then there was also one from NASA's coverage of the Curiosity rover landing. So, one event might be okay or just sort of a weird glitch, but 3 in the span of about a week or 2 is kind of troubling for trying to have things live streamed on the internet. And I think there's kind of a troubling precedent here at play for both, free speech and also, fair use and other related doctrines.
Yeah, this raises a whole host of issues. It reminds me of the early days of really the read-write web when people started blogging long before social media and Twitter were out there. And how we would constantly discuss at conferences whether people doing citizen media were doing journalism and whether that mattered. It seems to me that in the broadcast arena, that question raises its head again. The other thing that's a real concern here that is pointed out in Geeta Dayal's Wired article is that these companies, because they're trying to protect their content partnerships or protect their ability to have content partnerships, are taking proactive steps that aren't necessarily required under the DMCA. The DMCA would protect them to sit around and wait, as long as they've complied with what they need to under the DMCA until they get an affirmative notice that something should be taken down. Of course, that can get problematic when you're talking about something that's live. So they're taking these preemptive steps. Evan, what do you think about this?
Well, I think it should come as no surprise that the intermediaries are taking, going above and beyond the call of duty in being proactive in doing this, because just the nature of the environment is such that there's more cooperation between the content industry to make a generalization of the universals of the world, and collaboration between the content industry and the technology layer in all this, to make another generalization, for example, the Googles of the world. So, the fact that there's this activity, this proactive activity happening here should come as no surprise, because without it, there wouldn't be as much fostering of that synergy, of that collaboration and mutual forms of innovation, if you will. I guess the thing that's most interesting to me about all this is stepping back a little bit and examining what the best remedy for the problem is. Because clearly this is something that's frustrating, and it stymies the free flow of content to people who want to receive the content, consume the content, and should be entitled to watch it. For example, acceptance speeches at the Hugo Awards. We've got to be, or at least I try to be very sparing in quoting Arthur C. Clarke when he was saying that any technology sufficiently advanced is going to be indistinguishable from magic. But this is a perfect example of where that can be appropriately invoked. If we think about what the folks who first generated the idea of copyright in modern society. I'm talking about, the Statute of Anne, and then our founding fathers in implementing the copyright clause of the Constitution, all that stuff. Just think about how extraordinary this is that's going on here. The fact that these works are being performed, or let's just say it even in a more general sense, as the works are being created or distributed or whatever, they're appearing in other places of the world on this magical illuminated screen. And when you think about copyright and what its, what the principles are, that most people will agree that it is there to foster the creation of works. It's so crazy to think about how technologies like this are implicating those rights. And as far as fixing the problem, this seems to me to be a situation where we need to continue to advance the technology to put a solution on this, rather than throwing out all of copyright. Yeah, copyright certainly needs to be reformed, and there are things that could be done. But the right way to fix this problem is going to be through technological advancements and making it more semantically, the technology is more semantically aware, to understand the context, to take into consideration things like fair use and other authorized uses that that wouldn't create the stumbling blocks for the consumption of content that are being put in the way in situations like where the filters go too far.
Right. I may be comparing apples and oranges here. Sorry to step on whoever was speaking there. But it seems to me that broadcast television doesn't jump through these kinds of hoops when they are broadcasting something live. Now, granted, they're also generating their own content and not, hoping to build their businesses by having content partnerships with people who want to broadcast on their airwaves. But when they are, broadcasting something live, they're not subjecting it to some automatic robotic overlord, as Gita puts in her headline here, who is policing the stream before it actually goes out to make sure that there's no copyright infringement involved in their live programming. Rob, do you think that that this is a double standard here that shouldn't exist?
Well, it's somewhat of a double standard, but I don't think that you see that much infringing material coming over television. It's much more of an issue on the internet for whatever reason. But I'll tell you, this reminds me of the spam filters when they first came out. They would spam out. They would block much more than they should. Mm-hmm. I remember they blocked emails from the USPTO and the Copyright Office.
Right, lots of false positives.
Exactly. And I believe that, as Evan said, the algorithms are going to get better as we go. And eventually, hopefully it won't be such a detriment to do that, to take care of that.
Yeah, let's hope so. I mean, this is near and dear to my heart as someone who streams live on the web and often plays clips of things for fair use purposes in commentary on our show, and all of our shows do that. And we've already had issues with the content ID system at YouTube, but at least there's some back and forth there. You have the opportunity to at least chime in on why you think the thing should not have been pulled down. When somebody pulls down your live stream, as what happened, with Neil Gaiman and the Hugo Awards, you're kind of just out of luck. There is a short window of time when that is timely and consumable, and someone pulls it down, that window's gone. Evan, any final thoughts on this?
No, I mean, it's that other than to just reiterate what I was saying, that it's in situations like this, it's easy to get angry at copyright and think, this is such an oppressive system. I'm just repeating myself. Yeah, there are problems with copyright, but the better solution for things like this is through technology, where code being law rather than law being law in fixing these problems, because there are interests on both sides that are legitimate that need to be balanced.
Right. Yeah. The other thing that just kind of smacks me is, it's a business decision, but it's maybe not a business decision that every company would make who's in the business of, letting people's speech and expression get transmitted, that you're going to say, okay, we're going to apply these filters to the free accounts, but anyone who has a paid account, we're going to go ahead and treat them differently. I don't know. I understand the logic behind that, but it also makes some choices about who they think is more likely to be a legitimate speaker. Let's move on. We were talking about whether it's appropriate to get angry at copyright and the system that we have in place now. I don't know if other countries are getting angry, but maybe they're getting more realistic in the digital age. There's a good piece in The Economist that Jared Reimer put in front of us. Thank you, Jared, for always sending us great stuff. This is about different changes to copyright laws, particularly in Canada. In June, passed a new standard that caps statutory damages if copyright is breached for non-commercial purposes, expands the definition of their version of fair use, creates exemptions for educational purposes and parody. Firms must pass warnings about this is a big difference between the way we do it here in the U.S. In the U.S., we were just talking about the notice and takedown provisions of the DMCA and how that works on YouTube. what YouTube does is it has to take something down once it gets a notice under the law if it wants to avail itself of the safe harbors. In Canada, in a company in the analogous situation would let the person who posted the material know, hey, there's been a complaint. There's a warning about infringement for this, and they don't need to immediately take the content down. They leave it in the hands of the user, the direct infringer, perhaps, to deal with the problem of infringement. So this is going on in Britain. We've got internet-friendly legislation being introduced this autumn. In Ireland and Australia, we've got laws being passed to allow for format shifting, which basically lets things get stored in the cloud much easier and not have to worry about all the various copies that are being made. In Europe, for a long time, they've had a system where there were tithes assessed rather than trying to deal with infringement and licensing to get the rights holders paid. They just have been acknowledging that fees are necessary to be assessed to go to the content creators just to deal with the realities of the digital age. Evan, what do you think? I mean, is it time for the U.S. regime to start going the way of some of these other countries?
It would make good sense, certainly from the perspective of the end user. And this one issue is one that we talked about a couple of episodes ago about the difficulty of how difficult it is to do the right thing when you want to use content. So what I was particularly interested in this article here was the efforts to start these registries. I guess the marketplace for copyright. Particularly in I'm reading about this Britain where it says Britain plans to introduce internet-friendly legislation based on some research over there, where if you're a creative person, you're wanting to implement a work into something that you are creating, thereby creating a derivative work. It would be nice if that was much a more seamless process, less friction in being able to obtain good quality copies of that content and to remunerate the person that owns the rights in that and who wishes to be remunerated, hopefully on reasonable terms and all of that stuff. So that seems to be the point where the biggest improvement could be made right away. The other things might be more long-term, a revisiting of the fundamental notions, for example, of what copyright means, whether or not the primary right should be, as the very name of copyright suggests, the right to make copies of something, or whether or not we should do a mind shift to think that the real important right at stake here in the digital economy is one with the right of access. We've talked about this a number of times before. Ernest Miller and others at Yale have really talked well about how if we want to really meaningfully revisit copyright, it needs to be more thought of as an access right rather than a copyright. So certainly it's never a bad time. It's always a good time to be thinking about how the copyright and the effects that it has and the way that it defines the structures of the marketplace can be improved to serve the interests of both the content creator, the rights holders, and those who want to continue enriching our culture with new works based upon and incorporating those pre-existing works.
So the name of this Economist piece is Letting the Baby Dance, and that's referring to the Lenz versus Universal case where Stephanie Lenz posted a picture of her then 18-month-old son dancing away to Let's Go Crazy, and Universal came on in and said, no, you can't. That's unlicensed. You can't use our song in the background. The landscape has changed since then, and there are ways. That was in 2007. There are now ways that people can put music into their non-commercial videos on YouTube and allow either the music companies to approve them and make a little money off that. There are definitely regimes in place that weren't there in 2007. But Rob, here's a question for you from Virgil in our IRC about this. If the U.S. were to go the way of some of these other countries and begin to alter the law to acknowledge some of these digital realities? Would the RIAA and MPAA go along with it, or would they be the kids that took their ball and went home?
Well, I believe they'd fight it, but I don't know of any other area in civil law, and maybe I'm not thinking of all of them, that would just because somebody complained immediately provide relief without going to court or anything else. I think that is a problem. You mentioned maybe we should go the way of some of these other countries and give people a chance to respond and keep their work on the internet. I think that is a concern to me, and it should be changed.
Yeah, it's nice to see this trend unfolding. What do you think, Roger?
Yeah, a couple of things here. One, the first thing that sort of struck me is that if you see at the beginning of this article, it says that the clip that was complained about had actually been online for 4 months and only 28 people had seen it. So obviously we are, as you said, in a different landscape where Content ID probably would have caught that. I think the positive takeaway or sort of information from this article is that it suggests that people outside the U.S. are moving towards things that we can look to as models. I remember back a couple years ago, I went to a conference that Public Knowledge had put on called World Fair Use Day, which is a pretty interesting thing, and I think they're continuing to do it. One of the questions that came up in the context of the conference was, well, fair use is really just an American thing. Should we work towards exporting fair use? And the thought was, well, actually that would result in harmonization, and the problem with harmonization is it tends to get things a little bit more stringent and more restrictive in terms of the user aspect of it. You know, it's not lowest common denominator. Often it's like longest common duration in thinking of scope of things like that. So I think there's some good positive opportunities and developments here. I also like the thing about, you know, big data where they're saying exemptions for if what you're doing is analyzing like big data sets and big collections of copyright protected material, that you wouldn't be implicating copyright infringement there, or that you wouldn't have to get permission serially for that. So there's that. Then the last thing to remember is that there's always the DMCA anti-circumvention exemption that happens every 3 years in the U.S. So I think that we can kind of look to this as examples that we can push for during that proceeding, and hope that other good developments can be developed there, and then we can import them here into the U.S. So that's a positive there.
That big data question is interesting because it's always intriguing to see areas in which different doctrines and bodies of thought kind of collide and intersect with one another, and that the obvious implication here is where copyright intersects with privacy, which is an interesting kind of a little bit of a novel notion. What we're talking about here is perhaps a loosening of copyright restriction for the benefit of innovation and further expansion of data mining, and making it more, I guess, less risky is how we'd want to say it, for these companies to go out and mine data, pull in, scrape sites and pull in data from databases in a bunch of different places without there being a risk of copyright infringement liability. But at the same time, it seems like the more that we do that, the natural implication on the privacy front is, well, there's a doing away with certain norms or standards defining the contours of what information about you may be mined out there. So one way of looking at it, unless we are particularly flexible in our thinking here, is that the loosening of copyright restrictions could be at the sacrifice of our personal privacy, in as much as the loosening of copyright restrictions is in the name of liberating the enterprise of free data, or of big data. Free, maybe, as well. Free as in speech. Something, I don't know. Yes,
exactly. Yeah, that's a good point, and one I'm going to have to try and wrap my head around a little further, I think, that will, I'm sure, pick up on subsequent shows. Right now, after we take a break here in a minute, I'd like to look at whether maybe Bruce Willis is going to take on Apple about their digital music licensing. Unfortunately, it doesn't look like he is, but we'll talk about that in a second. In a minute here, though, we are going to thank our sponsor for this episode of This Week in Law, which is ShareFile by Citrix. Now, ShareFile is the perfect solution to the problem of collaborating with colleagues and clients, sharing files like contracts, spreadsheets, and presentations. It's essential, especially in a law practice, that these important files are kept safe, secure, and under your control. And that's why I use and recommend ShareFile by Citrix. It's the easy-to-use business solution that allows you to exchange files quickly and securely. Now, right now, I am doing some work for a client where I'm drafting up some documents, and ordinarily I might just try and attach them as an email, but there are quite a few of them. Some of them have images embedded within them, you know, as the definition of document keeps evolving in our world, and it's not, you know, it certainly hasn't been text on paper for a long time. Now it's whatever data you're trying to send across the wires. And oftentimes, email just can't handle that. So what I do is instead of attaching them, I use my ShareFile account. And what that does is makes sure that the recipients get the documents. They're not going to have to worry about bounce backs. I'm not going to have to call them up and go, hey, did you get that thing I sent you? It's going to get there. They're going to have access to it for exactly as long as I want them to. So if this is something sensitive that we don't want floating around in the internet ether for a very long time, you can set it so it has an expiration date. You can allow editing by people who are allowed to edit. You can allow access in a very fine-grained way, you know, maybe read access for one person, write access for another. It's a really flexible and wonderful tool, and it's going to make sure that your items get to who they are supposed to get to, when they're supposed to get there, and that you're not going to have any issues about security. You can send files of any size with no bounce backs. You can control the access with all kinds of levels of permission. It syncs automatically, so you and your team will always have the most updated materials, and you can access ShareFile from anywhere, your laptop, your tablet, your smartphone. So here's how you can try this out for yourself. I want you to go to sharefile.com and click on the radio microphone that you see on the site. Enter the promo code TWiL, T-W-I-L, and then you're going to get a free 30-day trial. You can see what I'm talking about. Try it out for yourself. Remember, visit sharefile.com and type in the promo code TWiL. Thank you so much, ShareFile, for your support. All right, so we're here with Rob Hassett, Roger Skalbeck, and Evan Brown, and let's talk about Bruce Willis. You know, he's frequently flying from building top to building top. There was a report in the Daily Mail. He was very up in arms about his digital music collection in iTunes, and the fact that he had just gotten around to realizing that there is no transfer provision in the licensing that is involved in your iTunes library. He has 3 daughters, and what the Mail had reported is that Bruce was anxious to make sure that he could bequeath his whole music collection, which is several $1,000s worth of music, to his daughters upon his demise, or perhaps set up some kind of family trust that would manage and disperse them. His wife has apparently taken to Twitter and said, no, we're not contemplating, or Bruce isn't contemplating any legal action about this. So I'm not sure if any forward motion is actually going to be taken. Some of the reportage was hoping that Bruce would be the white knight who led the charge to resolve this issue in a judicial setting. I'm not sure that's going to happen, but it does raise the interesting point that a lot of people out there have invested a lot of money in their digital music libraries, and we're none of us getting any younger, are we, Evan?
No. It's funny that's why I was thinking that, you know, Bruce Willis's best days were as David Addison on Moonlighting, you know, with Sybil Shepherd. That's
absolutely
shows how I remember all this stuff. So it's interesting how stuff like this can like become the source of legend, because when you think about it, when you first hear the idea that Bruce Willis is becoming a champion for iTunes users who want to firm up ownership of the works they've done, doesn't that just sound like something that you would like dream about? You're like, wait, I had this screwed up dream that there were like news reports about Bruce Willis. What the heck does he have to do with any of this stuff? So, you know, and then it becomes kind of like a canonical doctrine of how he is the champion of these types of things, which sounds like it is more of just kind of rumor and stuff. But yeah, that's good for him if that's what he's wanting to do. All I know is that I can't hardly sleep at night worrying what Bruce Willis is up to. And so it's good that I can get some real information about what he may or may not be thinking.
Well, I mean, we're making light of this, but I do think that the licensing point is a fairly serious one, maybe more particularly in the library setting, Roger. I mean, we're not talking about a library being able to pass its collection on, or maybe we are, I mean, I'm sure that libraries have different licensing kinds of concerns and arrangements than individuals do. But in this world of digital licensing, as opposed to, we used to have stacks of albums sitting on shelves in libraries that people could check out, it's not the case anymore, is it?
Not at all. And it kind of comes down to, it's this question of, access or ownership is often sort of the dilemma in the library world. In the Bruce Willis example, I had sort of these visions of, him saying, I see dead people unable to pass on their materials to their heirs, that kind of thing. But yeah, I mean, that's something that we're struck with regularly in the library world. And I think part of the issue is that a lot of the licensing models tend to run to the individual. And it's the same issue, I guess, with, libraries entering into things like Kindle lending programs and things like that, where initially the models were, I can buy it or I can license it for myself, but I can't then transfer that to somebody else. And, it's whether or not Bruce Willis is actually behind this. I think it's great that the rumor came out, not inferring his daughter, of course, but the RUMOR in that process, because I think this is a great issue that we need to talk about. And I don't care if he said it, because I think it's great that his face is associated with a pretty important topic of, you've bought all these things, but what did you actually get? You got limited use until you die, and then, sorry, it goes away, which is really unfortunate.
Or, I mean, you keep talking about, it keeps coming up on the show, access versus ownership. And Dwayne Knight in IRC is saying access is ownership, and that there is, a workaround to this. It's not probably in compliance with Apple's terms of service or the other services that also use this kind of licensing. But, as long as you have the person's username and password, you probably have access. So if you put all that in your will, then your heirs are at least set in that regard.
And in the library world, at least, with big data projects and big sort of commercial things that you're purchasing, I disagree a little bit that access is ownership. I mean, in a sense it is, but we've bought some things where we physically we've purchased it, and what we end up getting are large, like DAT tapes or DVDs or something saying, here you go, you've purchased it. But without maintaining a platform for actually being able to interact with that content, download it, search it, find it, print it, those kind of things, it's meaningless. And it's similar to, sort of accessing anything where there's, DRM associated with it. When the DRM component fails, well, then access is dead and ownership is sort of meaningless. But getting DRM out of the picture, if you just have the stuff but you can't provide it meaningfully to your end users, then I think it's not entirely that access is ownership, but that's thinking more at an organizational level than certainly at a personal consumption level.
Right. Rob, a little earlier we were talking about reforming the laws. It seems to me like this is a situation where realistically there needs to be some rethinking and reformation of the way these licenses work. Do you think that there's any realistic possibility that will happen?
I think so. I think that if, and I'm going on a limb on this, but I think that if Apple studies this, that they'll decide and probably can be able to convince the labels to decide it's really not right for somebody that's a great customer buying, all those albums, all those songs, not to be able to pass them on to their kids. And whether it goes to so far as to let you transfer it to someone else, they're probably worried about the implications of that and how it could go further than they want it to. That it might be a way for the music to be transferred to too many people and not in a legitimate way.
Right. It might go the way of Apple's and others' software licensing models where what you're purchasing is a family license, and that maybe that has some set duration that could survive the first family member that purchased the stuff. But they don't do that with music or ebooks yet. All right. Speaking of books, let's see, Roger, you had a pretty interesting point. We were talking before the show about how Creative Commons was one of the very first things we talked about on This Week in Law, and it still comes up from time to time. Here, there's a very interesting thing that you caught where I think it's a medical publisher, is offering authors to be able to make their works freely available. In other words, I think for download and redistribution from their publications. But in order to make that option available, it's charging the authors $3,250 for the privilege. Can you expand on that for us?
Yeah, this is an interesting thing. The publisher in this case is Taylor and Francis. They're scientific medical publisher, and what happened is a faculty member who works here had written something, and it's being published by Taylor and Francis. And then that person got sent a notice that said, "Oh, would you like to make this freely available on the internet?" And of course, the answer is yes. I mean, that's kind of the stock and trade for law professors. Is you get things out there, you distribute them, and things like that. So I think that's a good model to strive for. Then the sticker price, though, associated with it was $3,250. And then, interestingly, not only is that, I think, nigh unconscionable, at least more expensive than it really needs to be, the two things that are interesting here are the Creative Commons license they select is attribution, non-commercial, no derivatives. So you couldn't, arguably use it in a commercial setting where you're maybe a scientist wanting to access these materials for research. That's I guess a point you could argue. But there's that issue of which license they chose. But then also you could just get a subscription to the journal for $226 in print or $955 online. So that's kind of weird. And the last irony to this whole thing is that if you want to read about the publisher's plan for this open access program, which apparently they launched way back in 2006, the article that describes it is actually protected by copyright, so you can't get access to it unless you pay them money to get into it. So right. It's just a weird little situation here that they're moving into.
Well, and it seems to me like they're just moving themselves toward obsolescence. Did your professor perhaps make the decision that he or she did not need this particular publishing company and that they could directly publish this item and you choose any license that they liked?
Well, I think what resulted in this came at the end of kind of the publication cycle. So it had been submitted, edited, and almost finalized, and they're just inking the last, agreement saying, "Oh, it's about to go to publication. Can you sign here?" Or, these are the final terms. So that was kind of the unfortunate side. Is I don't think that there was really a choice there not to publish it. But what we try to counsel our folks on is to go into these with the assumption that, or with the argument point of trying to get open access. And whenever we have it, we put it online, or we encourage them to, distribute it through something like SSRN, which is a working paper site that a lot of law faculty use, or things like that. But in this case, I think it's up, it's there, it's commercially available, and you've got to pay to access it, or, be associated with an institution that has a subscription. We didn't pay $3,250, so people could get a non-commercial access to it, though.
Right. Evan, what do you think about a publisher that puts that kind of a sticker price on a Creative Commons option?
My first reaction is to think that has to be some kind of fear in the role of the publisher as an incumbent in this, trying to extract value, as Roger's describing, maybe at the last moment on this, realizing that there is this movement, this overall general sense for works to be available under less stringent conditions, like, Creative Commons. So, I would leave it to Roger to go into the nuances, given his familiarity with the industry and the various human factors at all this. But right off the bat, it smacks of some kind of activity to try to protect the integrity of the legacy system in the position that the publisher seems to enjoy in all this, putting a price tag on freedom like that.
Right. I mean, it seems like the publisher has started from the premise, we must get paid. It doesn't matter if economies are changing and you want to give free access. That's fine. But we're going to have to get what we would have otherwise gotten, if we were able to charge all those people to gain access to your article, which of course assumes that people would have actually paid it, which I think is a big assumption that the entertainment industry makes all the time about piracy that's not necessarily correct.
Yeah, I was going to
Rob?
going to make a similar point when we were talking about the Lens case just a while ago, and that Let the Baby Dance article. I didn't realize this back in 2007, 2008. Whenever we were, we've talked about that case on the show when it came down. I didn't realize that it only had 28 views when Universal sent the DMCA notice to YouTube to have it taken down. But maybe in Universal's mind, it thought it should have been paid 28 times, for that Prince track. So that it's crazy how. Literal and how, nitpicking and bean counting content industry can be and all this stuff. So who knows what people in that situation will say with a straight face.
Well, and it certainly had more than 28 views by the time we talked about it on the show. In fact, I would venture to say it's probably one of the most, I don't know. Yeah, I don't know YouTube stats, but it's certainly become very popular and well known since because of the lawsuit. So they went ahead and Streisand affected themselves.
Right.
Rob, what do you think about all this?
I write a lot of articles. And like any author that is in the position I am in or a professor is in, we want the articles distributed as widely as possible. There is tension with our publishers because they want to make money on the articles. That's the distribution is not what they're after. I think that if the publisher made that point at the beginning of the negotiations, right up front, then it's up to the writer whether they want to write the article or not. But like Evan, I believe, said, it's not fair that it comes up at the last minute. I don't think it really hurts the publisher, though, when the article is distributed widely in the way that it would probably be distributed here. It'd only be going to experts, and the experts would then know about the publisher in a lot of cases and buy more stuff from more works from the publisher.
All right. Well, I think we have pretty much closed out our first group of copyright stories, but we do have some that relate to Hollywood, so let's take a look over there. All right. Well, we have a lot of crossover between our copyright stories and our music, entertainment, and Hollywood stories this week. I'm going to throw one in that really isn't about the entertainment industry, but it's more geographically about Hollywood because Bikram Choudhury, if I am saying the yogi's name right, has been pursuing his former students for quite a many years. I'm one of his students, not directly. I've never taken the teacher training, but I do Bikram yoga, so I follow this, and we've talked about it on the show before. He has gone after various people who have tried to teach similar kinds of hot yoga under copyright law. He has obtained a copyright from the Copyright Office and has actually put several studios out of business because they're not his official franchisees and he doesn't like what they're doing. Actually, we've gotten some word from the Copyright Office on this. And whenever the Copyright Office makes a pronouncement, of course, it affects more than just the parties involved. So it's interesting that the Copyright Office has looked at Bikram's claim, or the claim, that one can copyright a bunch of yoga postures put into a sequence, and has said, this actually is something that has utility. It is done for medical and health benefits. And something like that is not actually subject to copyright law. It's really more the subject of patent law. So even though the Copyright Office, this gets a bit confusing, did say that Bikram could copyright his sequence, it's pretty much saying in the statement that it issued recently that it made a mistake and that it won't do that again. Bikram still has his copyright and can go out and continue to pursue people, but perhaps it will stop here. Now that we've kind of pretzeled this up, Evan, what do you think about this? I mean, it seems like this is certainly not the realm of patent law either, correct?
It doesn't seem like it's the realm of patent law, and there's a couple of interesting ways to approach this whole situation and things to say about copyright law and copyrightability in all this. I mean, backing up just to get to some basic copyright doctrine in all this, what the thinking, or at least what Bikram's thinking is in this, is that he claims a copyright in the selection and arrangement of these poses, the asanas. And so, you know, what he's not doing, this is important to note, is he's not claiming a copyright in the actual poses themselves, which I guess have been around for years. You know, you could go to the works of Patanjali and, you know, everyone else to see how folks have been doing these poses for many millennia. But the selection, the creative effort that comes into here to rise this to the level of copyrightability comes in the selection and arrangement of choosing which poses to do in what sequence. And I guess I haven't looked at any copyright registrations or delved into this, but what I'm guessing is that this is it could be a choreographic work, you know, choreographies or things that are protected by copyright, or I guess it could be protected as a literary work, a description of the sequence of poses and all of this stuff. So, you know, I understand the criticism and the critique here that this is, and in particular, we, you know, in preparing for the show, we looked at this article kind of criticizing Bikram over at the Knockoff Economy. It's an interesting blog. I hadn't seen it before, but it was saying how, you know, this shouldn't be copyrightable because it's merely functional. It is, and this is kind of going back to the patent question, whether this is something that's more for that, because these have, you know, the arrangement of poses in this sequence has, according to Bikram's own words, a medical benefit and a health benefit, and you know, you go into this, what is it, 180, 190 degrees, or maybe a little less. Way too hot.
106 to 110.
I went to exactly one Bikram yoga class once, and that's probably as many as I'll go to. So, you know, it has that functional benefit, but yes, it does have a functional benefit, but I don't think it should be that qualifies or disqualifies it from copyright protection. I'm not sure that I can put my finger on really what should qualify it from copyright protection. So maybe it should be copyrightable. This sequence of you know, the selection and arrangement. We don't. This is like becoming a motif, at least for me in the show today, where this is like the second or third opportunity I've had something to say like this, where this is a situation where we shouldn't be mad at copyright. Let's not get mad at the body of law that is giving rise to this assertion of rights by the copyright owner here. This is just an over assertive person claiming rights that, even if they really do ultimately exist, they're very thin rights. You know, that's kind of a term of art we use to describe certain level or certain strengths of copyright protection going after someone. It's just a very thin copyright. I was trying to think of a good analogy for this.
I've got one.
Go for it.
Soviet Russia, where laws were overbroad so that they could be selectively enforced. I mean, I'm reserving the right to be angry at copyright about this.
Okay.
Because
well,
I think that, you know, we've got situations that come up where people who have deep pockets and a lot of stomach for the judicial system can really use the laws as a sledgehammer that they weren't intended to be.
Yeah, but I mean, there's still an important role for copyright to protect anthologies, for example. I mean, I think that an English professor should be rewarded if he engages in extensive study of the works of Shakespeare and selects and arranges certain ones to be included in the book to the exclusion of others, even though the works of Shakespeare have been in the public domain for a long period of time. That's just an easy example. What the metaphor that I was wanting to get out was, this is just like, I mean, we really shouldn't treat Bikram Chowdhury with the hammer of copyright or lack of protection, but really we should just maybe speak through our decisions to not do Bikram yoga, and vinyasa is much better anyway. And to not pay these amounts, not go to his studios to do this stuff because he's acting rudely by asserting copyright rights in this way. The metaphor I keep wanting to get at here is like when you're riding on an airplane and the person in front of you, yeah, I guess they have the right to recline their seat back. And me being 6'3", flying, economy, that's particularly irksome to me when the person in front of me does that. You know what? It's not unlawful. It's just rude that they did that. Yeah, they have the right. Am I going to be their friend? Am I going to go invite them to have a beer with me after we get off the plane? No. Just like I could decide not to go to Bikram's studio because he's being rude in the way that he's over asserting thin copyright rights. So I'll get off my soapbox.
You might need your vinyasa class after that flight, but not a Bikram class.
For sure.
All right. Well, Grooveshark apparently has made its way back into the Android marketplace after having been dropped out of there because it is facing legal action by many of the labels. Grooveshark, I guess, is trying to be a Napster or a Grokster kind of service operating without all of their issues. I don't know if it's possible to do that, but I think they're giving it a try. They're allowing people to upload music and share copies of that music with other users, and then, taking things down when they receive takedown requests. So they're trying to use the DMCA as a shield. That's a whole separate lawsuit that's being litigated. Apple has booted it from the App Store. Google had done so too, but has reinstated it over in the Android marketplace. I don't know what more to really say about that. We don't know, Google hasn't issued any statement about why it did so. There was a decision in New York that came down in Grooveshark's favor, where Universal Music was trying to argue that that not responding to takedown notices was enough to insulate the service from infringement claims, at least when it came to older recordings. The judge there, Barbara Katnick, and I'm finding this over on the WSJ Digits blog, found that actually Grooveshark was in the right there. And so that could be what's behind Google's move here, but Google's not talking about it.
You really think so? I mean, that would only apply to like pre-1972 recordings, right? I mean, isn't that a pretty small set?
Yep.
If Katy Perry isn't involved in that, I don't care.
Right. Sort of a post-hoc ergo propter hoc argument that the Digits blog is making here. There just happened to be this decision that came down. So anyway, there's that. And don't know much else to say about that. Does anybody else want to chime in about Grooveshark before we move on?
I want to say just one thing, and I don't have the article reference to this right now. I was looking at this issue going into the show here. One, I've never used Grooveshark, but I've heard people who really like it. But one of the players, as I understand it, in the interaction with Grooveshark and the music industry is EMI, and I think I understand that EMI actually had entered into an agreement with them, and now at this point EMI is objecting to Grooveshark and saying that because they had an agreement of setting a certain level of licensing terms and things like that, for the EMI content in particular, Grooveshark couldn't rely on the DMCA notice and takedown aspect of the DMCA because they were actually violating the terms of their agreement. And I think at the heart of it was that EMI, as I understood it, had complained that they weren't getting paid enough royalties for the materials that were covered in the agreement between Grooveshark and EMI. Again, I don't have all of the details in front of me for that, but I think that's an interesting thing where, you could get outside of the DMCA aspect, or, sort of the fallback of notice and takedown regime through contract, and that might come into play sort of to Grooveshark's detriment potentially. So that'll be an interesting thing to watch as this unfolds, because it's a little complicated as to where things are at. But interesting that they're getting back in the Android marketplace for that.
Yeah, it is. All right, we'll continue to keep an eye on that. But in the meantime, let's head on over to take a look at some issues about the social web. This is an interesting and I think an encouraging decision out of an Iowa Court of Appeal. We're getting this through Venkat Balasubramani over on Eric Goldman's blog. Oftentimes, in recent days, we have seen Facebook postings come up in family law proceedings. What was going on here is an action attempting to remove children from, I forget if it's one or both of their parents, but certainly their mother was involved. So it was not just a custody issue, but are you caring for your children properly issue? And what happened here is evidence was introduced, and the court took it in a limited capacity of a picture that appeared on the mother's Facebook page of a marijuana growing operation. Now, there was no evidence that the mother had posted this or even knew that it was there. And the trial court said, I'm going to accept this as, for limited purposes, that just the picture was there on the Facebook profile. Not that the mother was engaged in marijuana growing or knew people that were engaged in marijuana growing or had anything to do with the picture being on her profile. But the Court of Appeal, looking at this, said, nope, that's not good enough. This picture never should have come in, that it was too prejudicial to have it come in, because we have no idea what the provenance of this photo was. There's no indication, no evidentiary foundation laid for who it belongs to, how it got there. So it's really nice, and here's what Venkat has to say about it. It's nice to see courts recognize that content posts or photographs can appear on someone's profile, but this does not mean that the page owner necessarily posted it or even agreed with it. Absent evidence that the mother actually posted the photos, it makes about as much sense to admit them as it does to admit a random photo that's sourced from the internet. So good outcome here. Evan, do you think courts are getting more savvy about all this?
I have a feeling that this was just a court that didn't really know what was going on factually here, and I'm not blaming the court. It's probably more likely, and I actually shouldn't blame the lawyers here because I have no idea what they did. I haven't looked at the case file and all this, but it seems plausible to me that a little bit more thorough lawyering here could have avoided the difficulty, because, it shouldn't be a mystery how a picture gets onto a Facebook profile. You can do a little bit of discovery and figure out, who posted it, when it was posted, from what IP address, so a little bit more thorough investigation could have happened here, where I think that if there was just even a little bit of testimonial sponsorship from someone, whether it be the woman herself or, I guess, if you had some other sort, it would be pretty expensive to actually get someone from Facebook to sit for a deposition, all that stuff. But there have to be other ways to authenticate this and show that the mother posted this and that it was put there. And I think that had those further efforts been taken by counsel in this case, there wouldn't have been much of a dispute on this, and that it would have been perfectly admissible, given the way that it was, and there was that uncertainty remaining as to what the provenance of this photo on the Facebook page was. Yeah, the court came to the right decision, because especially with Facebook, photos can end up on your in your profile, associated with your profile through no activity of your own. So it leaves open the question as to whether or not whether it goes to the ultimate question in the case of whether or not this woman was a good mother. Maybe maybe everybody was just too stoned to think of these things while they were
Well, if you're stoned and you're signing up for Facebook, you are really in a world of hurt, because I recently reacquainted myself. My Facebook profile is really, really old now, and I haven't helped anyone open a profile in a long time until last weekend, when I was up with my mother-in-law. She has a grandchild who's traveling in Europe and really wants to keep up with what she's doing. All that's getting posted to Facebook, and so the only way to do that is to get her an account. And it was so instructive to go through the process. I said, okay, I'll set you up an account, but you let me set all the privacy settings and all the tweaks to your information as to who can see what. It was so eye-opening to go through and see just what they have done to default almost everything to public. And it's really, really, we talk about it a lot on the show, but you don't really realize it until you have to go through and uncheck all those boxes for someone. So, if this poor mother was impaired at all, I'm sure she has no idea what pictures were showing up on her Facebook profile, and probably if she was stone cold sober. Rob, any thoughts on this?
Well, it reminds me of the Napster type of websites that would your child would think they downloaded a song and they closed it, but it really wasn't closed, and it was open. Could result in us seeing it result in a letter from the record industry going after the owner of the computer, and no one at that owner's house having any idea that they ever had left that on. So that's how, so that I feel sorry for the woman. In this case, she may have had nothing to do with this. And it could be that I don't know if it was a fight with her spouse or with the state, but anybody could have put that on.
Right.
And I don't know that it could always be traced.
Yeah. As soon as you're tagged in a photo, if you have not, turned off that default, it shows up on your page. So lovely. Let's move on. The Eagles always used to wonder what she was going to do in those shoes. And if you're really swank and happening, you might be wearing some Louboutin shoes. We've talked about this on the show before, even though it has very little to do with tech. It does have to do with trademark law. And again, one of those things I'm just kind of interested in, shoes and yoga. There has been this lawsuit where Louboutin has been going after Yves Saint Laurent, and I don't know if there are others involved too. Certainly, you see the very distinctive red sole against a contrasting background, usually black, on women's high heels, and the very expensive, legitimate variety of that are the Louboutin shoes, but other people have done it as well because that's been very popular. Louboutin just got a favorable decision from the Second Circuit Court of Appeals saying that what you can do in those shoes is not have contrasting black soles unless you are Louboutin. You can make monochromatically red shoes, so you can include red soles on the bottom of an otherwise red shoe. But if you have a black or any other kind of top and just the red sole, you're going to be infringing on Louboutin's trademark. So watch what you're doing with your shoes, I guess, is the moral of that one. I just wanted to follow up on that because we've covered that on the show before. And let's talk next. I don't know, Evan, what do you think would be interesting to talk about next? We still have a lot left here.
Can I
rundown. Sure.
Denise here? Yeah, I wanted to just mention one real brief thing about the red shoe or the red-soled shoe issue there, because it's not really a tech angle per se about the shoes themselves, but I think that, this getting protection in the trademark area for color or design features or things like that, I think is something that could come up. And I don't want to go back to the big discussion of the Apple versus Samsung thing, especially that was widely covered in last week's episode. But, this issue of something becoming protectable by trademark could certainly come up in the phone space or the technology space or things like that. And sort of the two fundamental things that the court recognized here is that first, you have to have something that's inherently distinctive. So the red sole, you do that, and there's one of the articles shows like Renee Zellweger or somebody, you see people walking down the street and that contrast is there. But if it's inherently distinctive and then develops that secondary meaning, that's the point at which you can get this protection. So I think that's interesting to think about in the tech area where, rounded corners on a tablet, probably not going to be inherently distinctive, but there could be things where color or other features of tech products do grow to the level of being protectable in this area. So, this is just about shoes, and I think it's a pretty interesting case, but it doesn't have to just be about shoes down the road, especially in the Second Circuit, which covers New York and pretty high-tech area.
Yeah, that's an excellent point, especially against the backdrop of the big Apple versus Samsung case. Evan, what do you want to talk about next?
Let's talk about that app that Apple kicked out because it reported drone strikes from publicly available information. You know that story?
Let's talk about that. That's fascinating.
Yeah, because what as I understand it, what's happened here. I've just read this article about it. There was this app that would query various news sources and others about where drones had launched airstrikes in Afghanistan and maybe other places, and it would show visually, I guess, on top of it was using the I don't know which API it was using, but it would show it on top of a map. And Apple apparently pulled it out of the App Store for and it's not really clear why. It doesn't doesn't violate. It certainly doesn't use any classified information. It doesn't really put anyone in prospective danger because it's reporting on things of what has happened in the past. So it seems like the questions are here. How much latitude should we give someone like Apple in the position of Apple to be the decision maker on applications like this that inherently their inherent function is to distribute information that is of important public interest? In what circumstances would Apple wield that power in a way that doesn't serve us well, and how do we draw those lines? Are the obvious, interesting issues that come up from something like this?
Yeah, I was really concerned when I read about this because, it's pretty and well, maybe not pretty considering the subject matter, but it's graphical. But just because it's graphical doesn't make it anything other than a news aggregation app. And if Apple is bouncing news aggregation apps out of the App Store on a content basis, I think that's pretty problematic. Maybe there was something else going on with this app. Maybe it was otherwise not in compliance with the terms, but that's not how the reporting has been going on this. Roger, any thoughts?
Yeah, I think on this one in particular, I think it's really interesting that there's this news angle of, is this journalism censorship? And what does this do? Because in the past, it was the ones that got rejected by Apple tended to be a little bit more, well, there's poor taste or duplicated functionality. So it was either, wanting to kind of keep things pristine or wanting to keep things, locked into their ecosystem and prevent, their device from doing things they didn't anticipate. But moving into this area where it's a journalistic aspect, I think it is a little troubling. As is pointed out, I think in that article and other places, there's still, HTML5, developed websites and other ways that you can get to this kind of content. But, to reject it outright simply for these kind of, content objections that, are arguably or defensively, justifiable as to what is included in them is a little troubling. So I hope it doesn't happen more.
I knew that HTML5 is pretty cool, but I never knew it would actually save democracy. But, like looking back on it now, it seems predictable that HTML5 could fill this niche because, it takes it outside of the walled gardens of, the Apple ecosystem, and there's still a certain barrier to entry into things being distributed in Google Play Store and things like that. So HTML5 is the way to keep us all fully informed and responsible members of free society.
Here it comes to save the day. It's the mighty mouse of web applications. Rob, do you think that Apple's getting political here? Do you think it has? I don't know. It's hard to guess what's going on in their analytical decision-making process here. But do you think that Apple is starting to reject things from the App Store because it doesn't agree with the political statement they may be making?
And some of that, I think that they're playing it safe, just like corporations try to do. Mm-hmm. There are laws that require telephone companies, which is kind of way in the past now, that were locked in. You were locked into a telephone company, and there were laws that require them to carry whatever you happen to want to have carried. And that's true with the internet service providers too, generally. But Apple is in another category because it's wireless. I'm not sure that's going to remain. But I'm not really. I don't want to indicate that I'm in favor of requiring Apple to not be able to terminate for any reason they want. The way I look at it, if they do that, then and the public doesn't like it, then other companies will get a competitive advantage. So
along those lines, there's a great article that Evan pointed to this week in the New York Times about our friend Alex McGilvery over at Twitter. And Twitter's efforts to protect user account information, both the public information that's been posted to people's accounts but is no longer publicly available because Twitter only goes back so far, and their private communications and information. As Jonathan Zittrain points out in that article, it's a real intricate balance that Twitter's trying to strike here, and he says if AMAC can help find a path through it, it may serve as a model for corporate responsibility for an internet where more and more code and content is governed by corporate gatekeepers. And I think some of that is going on here with Apple, that you've really got to think carefully about these decisions, what you're allowing people access to and what not. Evan, that was a great piece about Alex, wasn't it?
Yeah, that was, and he's the right man for the job right now at Twitter. Yeah. The way he has handled the various problems that have come up, whether they be in the Middle East or in India or even the domestic stuff with the Harris case in New York, the efforts that I think certainly Twitter has taken the appropriate stance for Twitter. And, Alex is no doubt probably the prime mover in the decision-making process, or certainly advising the decision-makers at Twitter when it comes to that. But, we've got to be measured in the principles that come out of that, because if you listen carefully to what I said, Twitter's doing the right thing for Twitter, and this is the right approach to it. The quote I wanted to pull out and kind of evaluate from the piece about Alex was, he said, you don't want business, and this goes right to what we're talking about with Apple, you don't want business interests affecting judgment about content that is against corporate interests. It's against the trust your users have in your service. And I think you mentioned that earlier, Denise. Not every company is Twitter. Twitter is sui generis because it's a platform for letting anybody communicate what they want about anything. And so not every company, and I would say few other companies really, maybe Google would be up there, and Facebook, so it's a definite top of the pyramid kind of thing, kind of a class of companies out there who, have an interest in being completely open and transparent like this. And so, I can think of several clients that I have advised who are dealing with problematic content on their servers, and they have every bit of legitimate reason for the furtherance of the mission of their company to be pretty selective about what they'll allow up there. I was about ready to use the word discriminatory, but that has a negative connotation that I don't intend to impart on this, Alla. But they are very selective and are quick to delete and censor content that doesn't go forward with their business mission. And I think that there's a place for that as well. And applying this rule that Alex is articulating and promulgating for Twitter, that would be bad for business. That doesn't apply to every online business, certainly platforms that have a more constrained mission than what Twitter does when it comes to the kind of content that they want going through there.
Yeah, good thoughts. And now you've made it so that Roger and Rob will have to drop Latin into the show at some point, since we've both done it now. And we're gonna make sui generis our MCLE passphrase, first one of the show. If you're listening along for MCLE credit. So let's look at a way in which Apple may be going once again toward business-friendly relationships rather than user-friendly ones on the patent front. Appropriate animation for this story. Because what's going on here is Apple has recently filed a patent that would enable third parties to remotely disable the camera function on iPhones. So let's say you walk into a concert and, the music industry has been up in arms about the fact that people just hold up their camera, get a little clip, post up, Katy Perry on YouTube live. Right. And, maybe the artists love it. It's a great way to show what a wonderful concert experience it is. But, I think lots of people have gotten takedown notices for that kind of thing on YouTube. So one thing that this patent would enable a venue to do is flip a switch, and everyone in the arena with an iPhone can no longer use their camera. You can find lots of, you can think of lots of different ways that this could be used, ways that it could be used by governments to prevent reporting or dissidents against unpopular government actions. So this is one of those patents that I'm not real wild about seeing out there, and I think could have wide-ranging ripples in the marketplace. And maybe we need something like HTML5 to come along and save democracy again, Evan.
Well, there is a potential positive side of this. Maybe Apple is acquiring a patent on this so it'll have exclusive rights to stop anyone else who would be more nefarious in applying this technology, so that Apple will never, put this. Apple essentially might become a patent troll when it comes to this technology. I'm just trying to be as optimistic as I can.
Yeah, let's hope so.
You see what I'm saying? They would, assert these rights, granted by the patent to stop somebody else from doing something similar to this, with no intention of actually putting it into market themselves. Let's hope that could be what they're doing here.
Roger, this is something a library, I suppose, could use if they were concerned about making sure people didn't come in and engage in copyright infringement by photographing chapters of books, etc., or whatever they're looking at that might be subject to copyright. But I certainly don't think Georgetown would do this.
No, I don't think we would. And, we always sort of take an approach of, put the reproduction equipment far enough out of the public's eye that we don't have to have that sort of policing connection to it and things like that in that approach. As Evan pointed out here, sort of an irony is if this is something that is, that Apple actually does incorporate into their products, or even if they don't, I mean, it's hard to think of this as a commercially viable or even sought after technology. It's not like, I'm going to get the iPhone 6 or 7 or whatever it would be because it's got these copy protection things. So I doubt that if they put this into their devices, they would then be going after others who have incorporated it. Or it might be, a way for Android and even, Windows Phone and things like that to differentiate themselves, saying, we're not the one, bring us to, the next conference or things like that, get a Nokia burner phone and bring it to, the Katy Perry concert and have a good time. So maybe it creates a market opportunity for the other players in the field instead of a potential downside for Apple users.
All right. Hey, Rob, the SEC finally took some action about the Jobs Act enacted back in April. We have crowdfunding becoming more of a reality, but in a limited kind of way. Can you try and make sense of this for us in a simple way that we who are not corporate lawyers will, or maybe some of us are, but that all of us in our audience can readily understand?
Sure. Under the security laws that govern investments, you cannot, up to now, you cannot solicit generally solicit or advertise the sale of stock or bonds or any other security unless you are registered with the Securities and Exchange Commission. In other words, unless you are a public company. And to become a public company costs legal fees of between $500,000 and $1 million. So most, not just most, I guess all startups start off as private companies and get there and engage in offering their stock in private offerings. And doing that, they are not allowed to do the solicitation generally or advertising generally. So, about everybody's aware of, crowdfunding, where you go on an internet site and you plead a story that you need money for the hospital or something like that. You can raise money back for that and get gifts.
Kickstarter, Indiegogo, lots of these things springing up.
That's right. And you could also raise money by pre-sales of your products. You may have a product that everybody wants, and maybe you can pre-sell it. But right now, it's illegal to solicit investors on a website, but that may be coming to an end. There was a new law passed called the Jobs Act. I believe it was signed into law in April, and provided that there's two situations that it dealt with regarding crowdfunding. First, there was a part that dealt with only accredited investors. And, sorry.
That's okay. Hey, let me ask you a question specifically about the SEC rules that just came out, and that you mentioned pre-sales and also grants. Are those going to be useful under the new rules? Because over at VentureBeat, they're a little bit disappointed with what the SEC did here. They were hoping that the ban on general solicitation would be lifted, but that's not what happened. What happened was we have rules that would establish various classes of investors, maybe each one of those classes with its own regulations. So it's starting to get really complicated here. Is there any silver lining to what the SEC has just given us?
Well, what happened is there were two different types of investment activities that could be taken with crowdfunding. One is when you're only selling to accredited investors. Those are sophisticated people who make a lot of money, or venture capital firms, or other situations where the protection is considered not to be as needed. That was what they call Title II of the Jobs Act. And Title III of the Jobs Act would let almost anybody invest, although it restricted the amount they could invest. And the Securities and Exchange Commission was charged with the responsibility for coming up with rules for the accredited investor situation within 90 days of the Act's passage. And for the one that was not just restricted to accredited investors, in 270 days, they were supposed to come up with final rules. But it's kind of complicated, and the SEC has not come up with final rules for either yet, and it's been more than 90 days. But for the accredited investor situation, they came up with proposed rules about the end of August. came up with these rules at the end of August, and the rules were disappointing to some people because they require, which has not been the case before with dealing with accredited investors, that all sorts of extra work be done to verify, if you're a crowdfunder, that the people that are investing and are supposed to be accredited are in fact accredited. So but here's the problem. I don't know if you're familiar with penny stocks, but they're ripe with fraud. Mm-hmm. And there's a concern by the security. One of the commissioners didn't even vote for these proposed rules because he didn't think they were strong enough. There's a concern that there'll be a lot of people that will be fleeced because they claim to be accredited investors and they're not.
Right.
Or even if they are, there's a concern that they will be not do the due diligence they should do. They'll treat it like it's a public company. And there'll be a lot of scams. So we've got objections on both sides on this issue. But the rules that were placed that are in effect now, they're not in effect, the proposed rules do go to a long way to making it very difficult for the issuer, because he's got to make sure that the investors are accredited. He's got to do a lot more than they used to have to do. If he's wrong and he did all the things he's supposed to do, the issuer would not be liable, but otherwise he would be.
Right. So the SEC is trying to chart the middle ground course and make sure that the fraud is kept to a minimum, or at least the risk of it is, while still making this kind of funding an option where it hasn't been before. Am I getting that right? Okay.
That's right.
Well, we'll keep an eye on this. I've thought the Jobs Act was a really interesting development on a number of fronts. And since we had this recent statement from the SEC, it's good to see that things are moving forward. And we really appreciate your insights in helping us understand how the SEC is tackling this. Let's see. We have a library story for Roger here about Magnatune and how, where is this? Somewhere in the Midwest, I believe. Roger, correct?
Yeah, this is in Ann Arbor, Michigan.
There we go.
Yeah, exactly.
It's just a flyover state.
Yeah. Apologies to Michigan.
No. I grew up in the Midwest, so yeah.
Yes.
And actually, just one thing I wanted to note or check with you on is, are we getting to this also for the resource of the week?
We will, but before we do that, let's describe how Magnatune can be used by a library.
Yeah, this is sort of interesting. I caught it in the show notes as we were building into it. I hadn't used it before, but what Magnatune is what happened here at the Ann Arbor, Michigan Library is that they wanted to be able to provide their users access to music. People come in, they want content, they want to be able to get it without, cost as an end user. And so what they've done is they have chosen Magnatune to partner with so that their end users then get access to it's copyrighted, but DRM-free music that they can download and get as part of the licensing agreement that the library entered into with Magnatune. And I think the terms of it, which are laid out in the blog here, are that it's something like 10 cents per library user. And it ended up that for the 62,500 tracks that their users downloaded in the course of a year, it cost the library about $0.25 per track. So looking at that in terms of their metrics, they said a couple of things. One, actually, that's pretty good in terms of usage. Often it might cost as much as $1 or more in terms of overhead of cost of, like, say, circulating a book or acquiring physical goods. So that's a good value proposition there. And also they got questions from library patrons and things, said, well, okay, this is fine, but what's going to the creators of this content? And it turns out Magnatune does, I think it's about a 50-50 split. They take half and then they give half to the artists that they have within their catalog. So I think it's been kind of a win-win in terms of that. And it's an interesting model where this is DRM-free content that people can go in and download, but it's made available in a way that I think is pretty palatable, both in terms of the creators, but then also in terms of the consumers of the content. So I think they're a good model to look to in terms of library offerings, but also just in terms of general access to, copyright protect. Well, in terms of creative content. So pretty interesting things there, and pretty nice write-up for what was otherwise a relatively kind of inside baseball sort of localized story about, developments at the district library level. So
right.
Pretty fascinating what they're doing with it there.
Right. And that does lead us right into our resources of the week, which are twofold. I bring these up because a couple of episodes ago, on episode 176 with Ramona DeSalvo and Lauren Mulrain, we talked a lot about the music industry and what kind of good alternatives there were for artists out there. Jared Reimer, once again, emailed in, hey, I'm a big user and a big fan of both Magnatune and CD Baby, which are very artist-friendly distribution channels. Now, the major labels stay away from these distribution channels, but that doesn't mean that other artists should. As we just heard from Roger, Magnatune gives a full 50% to artists who distribute via Magnatune. I'm not sure what CD Baby's cut to artists is, but they have certainly been around for a long time, and I appreciate the reminder from Jared that they are not just a way to have CDs sent to you anymore, because I remember using them years and years ago when that's what you used them for. But no, they are a digital distribution and delivery service, and they help artists get their tracks on all kinds of formats. Let's see what they say here on their site. iTunes, Facebook, Amazon, Spotify, CD Baby, and more. So that's pretty cool. Nice ways to be friendly to both artists and users. And get music around. So Magnatune and CD Baby are our resources of the week. Our tip of the week is topical because there was just a decision today, I believe, in the ebooks price fixing case that involves Apple and Hassett and a bunch of other publishers who supposedly closeted themselves up to fix ebook prices higher than Amazon's, to force Amazon away from its low pricing model. The DOJ continues to investigate a bunch of those parties, but several of them settled, and a federal judge has just approved that settlement with three of the nation's largest book publishers. That gives them some closure in that case. So moving on from that, while this was still pending and the federal judge was considering whether or not to approve the publisher's settlement, a gentleman named Rob Cohn, I believe his name is, yes, Bob Cohn, is an advocate who thought that the settlement should not have been approved and wanted to file what's called an amicus brief with the court to give some further arguments as to why the settlement should not go forward, and was given a 5-page limit on the amicus brief. So Rob did something wonderful. Sorry, Bob. He filed a brief that took sort of graphic novel cartoon form and completely complied with the court's rules about fonts and lengths and everything else, and told this wonderful story of the guy trying to prepare the brief and the arguments, and a woman friend of his coming along and basically laying the whole thing down, exactly the argument that Bob wanted to make. And at the end, she gets patted on the back, you really should be a lawyer. And she says, no, I've got better things to do. But between the two of them discoursing in these, cartoon panels, they really presented a wonderful brief and argument, complete with citations to the relevant authorities, which are footnoted down at the bottom of the panels. So our tip of the week is cartoonify your brief. Unfortunately, it didn't seem to carry the day for Bob. his argument didn't manage to keep the settlement from being approved. But what a great way to submit a brief. Have you ever, I mean, I've seen some poetic briefs before, Evan, but never a cartoonified one. Have you?
Yes, never seen a cartoonified one. Seen some poetic briefs, and I think Judge Kozinski has issued some opinions in poet or some fancy languages as well. So this is clever. This is a good way to draw attention to the issue when this lawyer may have otherwise felt constrained by the 5-page limit. But Evan Schaefer, right? He's a blogger. He's been a blogger for years. He's down in Missouri. Mm-hmm. And his tweet pretty much summarized it. It's just like, please don't do this again. I think he was talking to everyone else. This is a thing that'll be funny and clever once. After that, it's going to be tired and everything like that. So cartoonify your brief in the future with trepidation.
With trepidation. I disagree. I think we got to see more of this. So that's why I put it as a tip. What do you think, Roger?
I'm sort of with Evan on this. Hopefully just once. It'll be interesting to see, do law students take this up? Do others take this up in terms of forms of expression? I don't know.
Your final exam?
Yeah. I mean, it sort of reminded me of when Google released their Chrome browser back in the day. They released a comic book for it, and it's like, oh, that's kind of cute or whatever. But the interesting thing is it's a way to distill down complex concepts to a way that A, they're consumed, and B, people talk a lot about them. So will it happen again? I don't know. But I read the whole thing, and I even scanned the table of authorities and looked up some of the cases. So in that sense, I think a lot more people heard and thought about the arguments than would have otherwise. Go at it with some trepidation. I saw one person write it up. Maybe it's okay in an amicus brief, but if you're actually one of the parties filing this, I'd say proceed with caution, because he might be sanctioned or otherwise run into some difficulty vis-a-vis a judge lacking in a sense of humor. So we'll see what.
All right. Well, since you're both thinking that this is now going to lack originality, I'm going to amend the tip to be songify your brief. Go ahead and auto-tune the thing. Yep. See where that gets you.
Songify, yeah. I mean, I got a little bit scared about being cute in pleadings and stuff like the first month I was a lawyer. I thought I was, this awesome because I was like handling this landlord-tenant case in county court in Arapahoe County, Colorado, and the plaintiff had said something just really outlandish and it was like very speculative and it was not based on any reality. And so I answered the complaint. When I answered that paragraph, I said, defendant is not apprised of the metaphysical status of the plaintiff's mind or something, like really cutesy like that, just using language. I wasn't drawing pictures and stuff. And the judge yelled at me and made me really embarrassed. And so I was just like, he's like, son, you don't answer pleadings like that. So I guess I'm just a little bit gun shy still. 10 years later.
Well, you're not really a seasoned litigator until a judge has yelled at you. So that was a good rite of passage.
That was only the first time I got yelled at by a judge.
And probably not the last.
I hope not.
I hope so. All right. Well, we'll make cartoonify our second MCLE passphrase for the show. And we'll go ahead and wrap up the show. This has been a really great discussion. All kinds of fun things going on out there. I'm sure we'll pick up some of these threads in the future. But in the meantime, it has been great to chat with Roger Skalbeck from Georgetown. Great to meet you, Roger.
Hey, nice to meet you. Great to be here in person.
So we've got you at WebLawLib on Twitter, WEBLAWLIB. Anything else you want to plug before we go ahead and let you go?
Yeah, the only other thing coming up this fall, it's sort of obscure what I do, but once a year for about 3 years running, I've done a ranking system of law school websites, trying to, up the bar and get people to think more about making things that are useful. So I'm going to try to run that again this fall. It's going to come out, and then we'll see what happens in terms of where things play out. So if people have input on those as to what's good, what's bad in terms of websites, let's take a look at that. And borrowing a page from something that Squarespace has talked about in some of their promo stuff, and probably be looking at things like responsive design in websites. So we'll keep an eye open on what the trends are for web design in terms of the legal space for that.
Oh, wonderful. So you're the Jacob Nielsen of law school websites, and goodness knows they need it. So keep up that great work.
I try.
Wonderful. We'll look forward to that report. Who's number one right now?
Let's see. I don't even know. I think this last time it was. Boy, this is bad because I really care about trends more so than ranking. I know the irony is that the person who won number one last year, they changed their website like a week after the results came out. So I don't think that people go on it that close. They must have
decided they didn't want to be that progressive.
Exactly. Yep.
All right. Well, we really appreciate you being on the show. Thanks for all your great insights and contributions. Absolutely. And Rob, it's great meeting you. Thanks so much for joining us.
Great fun. I really enjoyed this. Thanks for having me.
We know folks can find you at Internet Legal. Is there any social site you'd like to plug, anywhere else where folks can catch up with you on the web?
I have another site, tellmesomethingidon'talreadyknow.com.
Oh, I like that.
I have a good time with.
What's its purpose?
I try to put on, do transcripts of interviews and articles about things that I think my clients would want to see, which is hopefully everybody.
That's awesome. I love that because I used to, as sort of a nighttime ritual with my son, I would ask him what he learned today, and he immediately shut down about all that because, it's just not that interesting when you're a kid to think about learning and having to learn something and then talk to your mom about it. But now I ask him, tell me something interesting I don't know. And he loves that. He can always come up with something because there's always something mom doesn't know in his mind for sure. So appreciate that. And thanks so much for joining us today.
I really enjoyed it.
All right, us too. Evan, great to see you, per usual.
Yes, the same. Great to see you. Fun conversation. Lots of interesting topics. So looking forward to doing it next week.
Me too. So until then, we hope to see you all out on the interwebs. Come connect with us on Facebook and Google+, where we have pages and we talk about and develop topics for each week's show. All of our discussion points are aggregated on Delicious if you're ever looking for the list of everything we talked about or hoped to talk about. That's at delicious.com/thisweekinlaw and then the episode number. So this one is /178. You can find us in iTunes. Please get over there and give us a rating if you do listen to us in iTunes. We appreciate getting your feedback on the show that way. And you can follow Evan and I on Twitter. He's Internet Cases. I'm D. Howell. I'm also over on Google Plus and do a lot of stuff over there. And you can email us. We'd love to hear from you in email. He is Evan at twit.tv, and I am Denise at twit.tv. And so shoot us your thoughts and observations, and we will hopefully incorporate them into an upcoming show, which we record every Friday at 11 Pacific, 1800 UTC at twit.tv. So until next time, this has been This Week in Law. Take care.